The next component of contract law that we're going to be looking at are terms. Terms are really important because they are the actual promises that parties make, and they're the things that parties to a contract have to do. They're the obligations. And so broadly we're going to look at how terms get to be into contracts, and then how to interpret those once they're there. Now, there are 10 areas that we're going to look at here, but the primary one, the main one, is this concept of express terms and the distinction between those and implied terms. We're going to look at how statements that people make in and around the time of contract formation, how these end up being either included or excluded from the contract. We'll look at the Parol evidence rule to do with contracts in writing and exclusion of oral statements. We'll look at how these statements end up getting incorporated into the contract itself. We'll look at some specific types of contractual clauses in situation, onerous clauses, exemption clauses, and what happens when you sign a document. Then after that, we'll examine implied terms, things that aren't expressly agreed upon but nonetheless form part of the contractual duties of parties. Then we're going to look at another subcategory of contract called a collateral contract that can arise through the process of negotiating and exclusion of terms. And finally, we're going to go through the interpretation. How do we go about reading a contract, a contractual document, once it's in existence? Really though, the very first thing to look at is what it is that we're meaning by the word term. And again, we're going to go with a very simple definition here. It's just something that the sides, either of the parties, are obliged to do. There's a legal obligation, and the lack of performance of that gives the other side some form of remedy. There are many different ways of classifying terms, usually in terms of their effect or the consequences of breach for those. However, in this recording, we're not concerned about those aspects. Here, we are concerned about how those particular obligations end up getting into the contract itself. And really, there's two ways by which an obligation can end up being included inside a contract. There are either express mechanisms for it, and these are called express terms, where somewhere in the negotiating process, one or both of the parties went and incorporated that directly into the contract. And there's also implied terms that we'll talk about a little later. These are things that one or both parties may not have known about, may not have intended, but nonetheless end up being included in the contract through several different reasons. The first of these broad areas of terms that are incorporated into a contract are known as express terms. And the important distinction between express and implied terms are that there is some aspect of the negotiation process that's actually happened in the real world that somehow has led to particular obligations ending up being in the contract. There are three ways in which express terms can end up being incorporated or included into the contract. Now, the first of these statements are things that are said and done by the parties. Now, again, the most common one of these, of course, is a document to actually state and list out the obligations that each side has as part of this agreement. However, there are some other ways, and two of those, the first being notice, giving notice to the other party that there are some terms that they are seeking to have included into the contract. There are some specific rules to that in terms of how you can go about giving notice to the other party of terms. And the other is through a course of dealings between the party. And again, this may make sense to those with sort of commercial experience, that when you're dealing with the same parties again and again, in each individual time you transact, you may not be going through the exact same formalities of incorporating terms directly. Nonetheless, though, these can be included or incorporated in a contract expressly. When we use the term statement, we mean both a written statement, but it can also be oral statements that are made. And it's important to know that when statements are made, there are different amounts of legal effect that those statements can have. Broadly, when a statement's made, in and around the negotiating process, there's 4 broad categories it can fall under. Statements can be puff, and again we've referred to and talked about this in the previous recordings. An exaggerated statement or claim that doesn't have legal effect. Things can be representations, and there's a broad spectrum of how and what those mean, but the really key part is that while there may be some legal effect, representations are different and distinct from terms. Something that's said and done that actually is going to have binding contractual force is a term. And finally, later in the recording, we'll talk about collateral contracts, things that can arise as separate and independent contractual obligations throughout the process of negotiation. Returning to the case of Carlisle and Kamala Smokeball, puff is something that reasonable people would never think would be part of a contract. Now, one of the difficulties here, though, is that sometimes exaggerated statements of claim by one party may be not quite so exaggerated in the minds of others. And so, for example, the case from the early recordings was the Harrier jet landed in PepsiCo, where a person quite, the judge thought unreasonably, but certainly in that person's head, the idea that, well, hey, the ad said if I get 7 million Pepsi points, I can get a Harrier jet. This is problematic for people in business, and it's an important consideration to make. The examples here, for example, are batteries lasting up to 4 times longer. Eveready and Gillette went to court and they lost. Actually making a statement like that has something very tangible attached or associated with it. Reasonable people could look at that and actually think that that would have legal effect. It's not going to be puff in that situation. It is specific and it's believable. It's within the realms of possibility. Whereas the classic real estate agent pitch, stating that something has immaculate style, is going to be puff. Something that's commonplace amongst that particular industry, and it's sufficiently outlandish that, again, no reasonable person would think that it had any legal effect. However, in the same series of representations, real estate agent mentioned that while the thing or property had perfect presentation, they unfortunately used the phrase in Mitchell and Hillary that there was nothing to spend. And the court there said, no, that's not puff. You are actually making a claim or a statement that a reasonable person would look at and think, well, maybe there is something to that. Maybe that's more than mere puffery. And in that situation, that was not deemed to be puff and did have consequential legal effect. So if a claim or statement is not puff, it is going to be some form of representation, and it may have legal effect. It's important to note at this stage, though, that a representation that's not puffery, it may or may not have legal effect, but it won't have contractual force or any mechanism for a party to claim in contract law if it is not a term of the contract. This is a really important point. And this series of rules that we're going to go through is really going through and trying to analyze a particular representation to try and determine what the effect is. For the sake of this recording, though, we're most interested in the distinction between representations and terms. So representations that may or may not have legal effect in other areas of law, as opposed to terms. If something is a term, and there is an obligation as part of that term, if a party is in breach, the other party can claim some form of compensation. It's a really, really important point. Even though we're not going to delve into the underlying mechanics of what that compensation is in this recording, it's an important rule or series of rules to learn to know this distinction between the two. So going through this list, we have 3 different aspects of common law misrepresentation. So a particular statement that's made that isn't a term might still have some legal force, giving the innocent party, the one being lied to, some form of remedy. Similarly, there's a statutory regime that we'll discuss at a later date involving this idea of misleading and deceptive conduct. The statement, again, might not be a term, but might still be deceptive or misleading and give some form of statutory compensation or remedy to the innocent party. Also, in terms of other types of vitiating factors, such as unconscionable conduct or duress, the party making or issuing some form of representation or statement may give the other side some other way that they can go about claiming either some form of remedy or making a claim in equity for some form of compensation. Similarly, representations can lead to collateral contracts that we'll discuss a bit later in the recording. Probably important to note here is a bit of a naming aspect, which is, for the purpose of this recording, I've used the phrase representation and mere representation as 2 different and distinct things. So what we're doing is we're looking at a representation that is then categorized into one of these areas, one of which is to be a term. Representation can end up being a term if it's incorporated into the contract. You may find in some textbooks and some of the subject materials the terms representation and mere representation being used interchangeably. Here, I'm going to deliberately give them different meanings. So here, for the purpose of this recording, when I use the phrase representation, I mean a statement that's to be made or issued from one party to the other that is to go on and be categorized into one of these areas. This is different and distinct from a mere representation, which is our representation that doesn't fall into any of these areas. In other words, it has, not only is it not a term, it has no legal effect at all, but it's not puff. So the test that the courts use to determine whether or not a particular representation is actually a term that's now incorporated in the contract is called, colloquially, the contractual intention test. But fundamentally, all this test is seeking to do is to look at what the actual intention of the parties were at the time that they formed this contract. Now, where things end up being in dispute, it's quite difficult to go just as a matter of principle, to go and ask either of the parties. Why? Well, because it's in dispute. And so the courts have developed for quite a long time quite a high bar, a high threshold in terms of what sort of features and what pieces of evidence can be adduced to the court to try and determine whether a particular representation or statement that's made is a mere representation or a term. And so when trying to examine a particular statement, to determine whether a reasonable observer, this idea of this objective test of using a reasonable person test as part of this process, when using this test, we are trying to look at whether or not each of the parties intended for this particular statement or representation to have weight, to have its underlying truthfulness guaranteed. And if it turns out not to be true, the other party would be able to seek a contractual remedy as a result. So when undertaking this contractual intention test, the courts examine a variety of aspects and surrounding circumstances. And the first of these is any particular special knowledge or sort of skill or things very specifically known about the subject matter that each of the parties possess. In the case citation here we've got is Oscar Chesson Williams. And in that case, a person, Mr. Williams, was selling a car, Morris, to a dealer. And Mr. Williams had looked at the logbook of that car that said it was a 1942 model. It turns out it was actually a 39 model. And in that situation, the court said, look, if you are a dealer and you're purchasing goods from a person, kind of expected that you would have the special knowledge and skill and not the lay person making that sale. And so there, in that situation, the court said, well, no, the person representing that the car was a 1942 model in complete and good faith, in that situation, would not be sufficient enough for that to be incorporated and become a term of the contract. The next area the courts can look to when trying to determine the objective intention of the parties is to look at the underlying language that's being used. And this particular citation is J.J. Savage and Sons and Blackney. In that situation, there was a boat, and there Blackney had made it sort of clear when purchasing the boat that he was after one that could achieve a certain speed. And the salesperson for J.J. Savage had said, expressed, yeah, I estimate that it probably could get to that speed of 15 miles per hour or whatever it was. And the High Court said, look, the language that's used there it's really more a statement of opinion, an estimate. It didn't, from the court's perspective, it didn't have a sufficient amount of certainty or surety that was as a statement that was issued from the seller in that case. And so it's important to note there that where statements are very much phrased in the expression of certainty of certain things, and they sound promissory in nature, so they sound like they're promising something, the courts are far more likely to essentially impute this intent. Again, that a reasonable observer looking in on this would think that the parties intended for the truth of that statement to have some consequence, contractual consequence. A third area to look at is when the gap in time between the contractual formation and when the particular statement was made. And Routledge and Mackay, the statement about the year of a motorcycle with carriage, which turned out to be incorrect, was made, but it was made quite a few days prior to the parties coming together and actually enshrining that deal in writing, and that was the point of time where the contract was formed. And there the court said, no, there was sufficient time for the purchaser in that case to actually go through and investigate and find out. The next area the courts can look at is whether the particular statement that's been issued was in writing. Now, there is a rule, and we'll discuss later in this recording, that excludes everything that isn't included inside a written document if the parties intended for that to be the case. But it's not unheard of, and certainly possible in contract law, for a contract to be a mix or a blend of the two. And in that situation, where there are oral statements made and written statements made, and these are combined together, and the courts are having to go through and determine the intent based on all of these things collectively, then more weight will be placed on things that are put into writing, even if the document isn't wholly enshrined in one document itself. Finally, a really important component is whether a particular statement is going to be important. In Van den Eschardt and Chapel, a Western Australian case, there a person intending to purchase a residential property asked the real estate agent, are there any termites? And the real estate agent said, no, I don't think so. Well, something to that effect. Now, whether or not a person buying a house is buying one with white ants or without is a really, really important consideration. And the Western Australian courts essentially stated that, said, look, that it may have been an off-the-cuff statement from the agent's perspective, but from the purchaser's perspective, this is of utmost consideration and importance. And so on the topic of contractual terms and statements, It's probably important to note at this stage that there is a rule of law, not strictly speaking a rule of evidence, that states that in contract law, where the parties actually intend to enshrine a contract in writing, all of the material and statements that have been made up until that point, as part of negotiations and such like, are actually excluded by default from being terms in that document. And the idea is that, look, hey, if we intend for all of the terms to be encapsulated in a document, the statements that are made outside of that document that aren't actually captured in there aren't terms. Look, they may still have some form of legal consequence or bearing, but they're not terms of a contract. As mentioned, as an exception to the parole evidence rule, contracts that aren't intended to be solely enshrined in writing, that contain a combination of written and oral statements, don't fall under this umbrella of the parole evidence rule. Similarly, statements that are made can still have some form of legal effect. We'll look later at estoppel and also at this idea of collateral contracts, so that where a person is making a representation to induce the other party into a contract. And in our own lives, we could probably think of situations where this might arise, when you do have salespeople trying to encourage people to go to purchase often large assets, cars, houses, and such like. Can make all sorts of statements up to that point to try and induce the particular party into that contract. And so one of the aspects here is that while the parole evidence rule will exclude all of those statements from being terms of the contract, they can still have force in the form of another little side contract that we call a collateral contract. Later we'll also talk about this concept of implied terms, things that are incorporated into the contract but not as a result of negotiation. Now, if we think about a contract in the classic sense of being a document, sometimes a long document with lots of clauses listing and stating what each of the parties are obliged to do. Now, it's certainly possible in a contract to refer to other documents and have those incorporated into the contract itself. Now, when things are referenced in this way, in some situations it can be a very straightforward process. Oh, hey, here is a list of or schedule of additional features or additional terms or additional points that we wish to reference, and that can be paperclipped to the same document. In other situations, though, there may be a list of terms that are not directly referenced, and that particular list of terms or obligations needs to be incorporated, or at least one party is seeking to incorporate them, by giving notice of how and where those terms can be located. And we can probably think of some real classic examples of this in our own experience. For example, click here to affirm that you have gone to this link, read all of the 300 pages worth of terms, and agreed to all of the contents. How often do we actually go and do this? Exceedingly rarely. Now, there's a series of cases in the second half of the 20th century that involved the use of tickets and receipts, and whether or not statements of terms incorporated on those things would actually be included in the contract or not. And so a couple of sort of general rules that flowed from this is that as a starting point, you can incorporate terms into a contract by notice. You can do this. You can say, hey, our terms and conditions are stated on that wall over there, or on the back of your docket for your dry cleaning. It is okay as a general rule. But the courts have ruled, or at least tried to rule, generally in the favor of consumers in a lot of these situations. And they've said that, look, when you're doing this, you have to actually make these things clear to people. You can't just say, oh, over there, hidden away somewhere where you can never read, is a list of all our terms and conditions, and you're bound by them. That's fundamentally not what this is about. And so in situations, for example, in car parking yards where you pay some money to go and park your car for a period of time, there was a series of cases whereby the owners of yards would try to essentially get out of liability where cars had been damaged, usually by pointing to exclusion clause in the terms that they have on their wall that said, we won't be responsible for any damage. And what the court said is that, look, you can do that, but you have to make it really clear to people when they are entering. And that notice has to be done at that time. You can't do it afterwards. So you can't have a situation where I buy a ticket at the counter and then I get to read the terms of the contract after I've gone through into the particular location that I'm getting to. Now in Ollie and Marlborough Court, that was exactly what happened. The terms and conditions for the contract was on the back wall behind the door of the room. So people would go and pay for the room at the concierge, then go up to the room and then see the terms listed there. And there the court said, no, you really can't do that. Similarly, in Thornton and Shoe Lane parking, in that case, the car parking company is trying to incorporate these reduction of liability clauses into the contract. And there, sort of Lord Denning says, well, it's really a matter of fact. We have to go and look and examine whether or not the signage in the situation was right there when the person's getting the ticket, or whether they had to go beyond to somehow go and read that. And that first set of circumstances is okay. The second one, less so. Another way that express terms can be included into a contract is through prior dealing. Now, this arises when you've got two parties who have done business with each other in the past. And in that situation, the courts can actually impute that, hey, look, sure, the particular time that you went and had this agreement, the terms weren't given to you at that time, but you were made aware of them through earlier dealings you've had with the other party. And in the slightly famous and mildly comical case of Balmain, Newfair and Robinson, you had a person who used the ferry regularly, and he was very much aware that you paid a penny to get in and a penny to get out. And on one particular day, he paid the penny, got in, but he'd missed the boat, and so he tried to argue that he wasn't liable to pay the penny to get out. And this actually went all the way out through the courts, and they said no, this particular term, the paying when you get in, paying when you get out, that is incorporated into this contract as an express term, and because you knew about it. As a matter of fact, you were aware of all of the terms of this agreement when you entered into it. Now, there's a couple of exceptions to this. The first is that there has to be regular dealing. It's not sufficient to do things on an ad hoc basis. For example, have or purchase something at the start of the year and then purchase it again 6 months or 10 months or 12 months later. And it has to be regular. So you've had to have dealt with the same party usually on more than one occasion. Although, again, this is a matter of degree. Finally, as a point that sometimes arises in these sorts of disputes, that where there are courses of dealings between parties, and this type of dispute arises where one side is trying to argue that contractual terms are incorporated through prior dealing because they've had regular contact between the two parties. In these situations, it's not uncommon for parties to have their agents sign things like packing slips or delivery dockets. And this case of Rinaldi and Petroni and Precision Mouldings in Western Australia was an example of that, where the documents that were proffered by one or both parties in dispute weren't contractual in nature. And there they said that, look, if you are going to incorporate things through incorporate terms, express terms into a contract through prior dealings, and you've got these documents, they have to be contractual in nature. They can't have the properties of a delivery docket or a receipt in order for this hurdle to be overcome. Now I'm going to look at some specific rules involving written contracts, and we'll kick it off with Lestrange's case. This has been described by some jurists as the low point of contract law jurisprudence of the 20th century. I guess famous or infamous in some way, because there, the court in Lestrange and F. Grey Cub Limited, the court said, where you sign a document, you at law are deemed to have both read it, understood it, and accepted all terms contained in that document. This is a really harsh rule. In fact, if there's one thing that you take from any of the recordings about contract law, is that when you sign a document, you are bound by it. It doesn't matter that you haven't read it. It doesn't matter that you don't fully understand it. It doesn't matter if there are terms in there that you don't like or don't want. Now, clearly there are some exceptions to this. And again, this where parties were trying to incorporate things by notice, this idea that, such as in Curtis in chemical cleaning, where one party gives a document to another to sign, but doesn't actually represent that it is a contract and that there are terms in it. Instead, they state either overtly that it's a receipt, or they just don't say anything at all, and the document in its form doesn't look like it has any form of contractual meaning. In that situation, then yes, signature won't be sufficient to incorporate those terms on the back of the sheet into the contract. But it is still important to note that these are exceptions. The rule, in Lestrange's case, is still good law. Now, another exception to Lestrange's applies when there is a particularly onerous clause in a contract. In that situation, a party seeking to rely on this must actively take additional steps to bring this to the minds of the parties when they're going in to sign it. People need to know about particularly onerous clauses. It has to be brought to their attention, and that is up to the party seeking to rely on it to prove. So in Interfoto, Picture Library, and Stiletto, there a publisher went to get some prints, stock prints from a printing house of some sort, and they had them for 2 weeks, and there were 60, 61, 66 prints. Had them for 2 weeks and returned them late. And it turns out that in the clause, there was a clause in the contract that signed that said that they had to pay a penalty of £5 per day per slide. And so having these slides for the 2 weeks ended up coming to a ridiculous sum of money, maybe £3,000 or £4,000. And so the parties trotted off to court, and in the end, the publishing guys won, and the court said, look, in a situation like this, you've really got to bring it to the attention of the other party. Otherwise, they're going to rack up phenomenal bills as a result. Another area where parties usually are trying to abrogate responsibility in is in this area of contract law known as exclusion clauses. An exclusion clause is simply a clause in a contract that just tries to limit liability for one or both sides. Usually exclusion clauses are put into a contract by the more powerful party because they've got more power in the negotiating process. And the courts, to put it blunt, they don't really like these things. They accept that they do exist, they accept that they do have efficacy, they are a legitimate clause that you can put into a contract, but they're reluctant in situations where there's great power imbalance to enforce exclusion clauses, or at least where parties are seeking to rely on them in situations which sometimes can be very, very unfair, the courts will try to read them down and interpret them quite narrowly. So one way that they do that is to just look at the underlying exclusion clause and say, well, is this actually wide enough to cover the breach? So exclusion clauses that have been written too narrowly, for example, trying to exclude all forms of breach of contract, for example, or breaches of contract in a specific mode or manner, might not cover situations where a different sort of breach arose that they hadn't thought about, or to exclude liability and tort. The flip side of that, though, is that you can't have an exclusion clause that is so wide, because in that situation, arguably, you're not providing any consideration on the contract. So, for example, a clause that said, we will not be held liable for any breaches of contract, for any performance or any tortious responsibility whatsoever. In that situation, you could, in theory, just not perform, just choose not to perform, and try to rely on that exclusion clause in order to preclude you from having any form of action brought against you for breach of contract. So I guess the takeaway from this is that exclusion clauses, they are a legitimate type of clause to include in a contract, and generally the courts are quite happy to enforce these like any other clause where you've got two equally powerful parties. Now, in more recent times, exclusion clauses have been dealt with by Parliament, and in subsequent screencasts we're going to talk about how this works in terms of employment, in terms of consumer law and such like. The next area we're going to look at are implied terms. Now, these are terms in a contract, but they're not things that have flowed from the negotiations of the parties. These still are legitimate obligations that the parties have as part of their, that have full contractual binding force, but they have been incorporated into the contract in a different way. They're not express terms, they're implied. And this can happen either by fact, by law, or through some sort of trade custom. Now, the first area to look at in implied terms are those that are implied by law. There are quite a few of these. The common law and statute just dictate that when you form certain types of contract, that for policy reasons, those contracts must have certain clauses incorporated in them, even though the parties would never have negotiated these particular things, and sometimes neither party would actually want it. So, for example, there is an implied term by default when you sell goods from a person who really specializes in selling that type of goods. If you are buying them by description, there is an implied term that those are going to be of what we call merchantable quality. Now, a lot of these statutory rules we're going to cover in subsequent screencasts. I just want to draw your guys' attention to it at this stage. There are also rules that flow from the common law and equitable principles as well. For example, the duty of good faith and confidentiality that employees owe to their employer is not usually something that's negotiated with when people enter into employment contracts. Another reasonably obscure implied term is that when a person goes to a doctor, that person can get their medical records and access those. Again, it's not something that either party would negotiate, but nonetheless, it is an implied term in the agreement that they form together. Similarly, in consumer contracts, there's a bunch of implied terms in the Australian consumer law that essentially says that a person supplying goods to a consumer must ensure that they are acceptable in finish, they have to look sufficiently sound, they have to be free from defects, safe and durable. Now, another way that terms can be implied into a contract is by fact. This is usually not an easy process, and really that's because the courts for a long time said that if a particular promise as part of a contract is really important to a party, they really should encapsulate that and enshrine that in the contractual document. Nonetheless, terms can still be implied into a contract if these hurdles are overcome. First, that it has to be reasonable. Second, that it has to give business efficacy to the contract. So what does that mean? It means that the contract really has to be able to not be able to stand without that particular term being in it. If the contract operates satisfactorily without it, then the courts are very, very, very hesitant to imply terms into the contract as a result. The term has to be so obvious that it goes without saying. I mean, basically that means that a person who was looking at this particular contract from the outside would just go, well, yeah, of course it was implied in this contract that this, that, or this was supposed to happen as part of it, even though those particular things weren't included in the formal document itself. The term must be capable of clear expression. It means it can't be vague. It has to be understandable, tangible, and measurable. And finally, it can't contradict any express terms. Why? Because the express terms of the contract are what we've actually encapsulated and what we've actually agreed upon. And so as a result, we can't imply terms that don't sit with this. In essence, an express term is going to trump an implied term, or at least an implied term by fact. Finally, there is situations where trade custom can imply terms into a contract. Again, this is quite rare. Usually where people are operating in particular industries, the contracts that are commonly used in those industries incorporate these terms and they have them as express terms. But nonetheless, a contract can have these implied if there is a particular custom and it is so well known. Everybody in the industry knows what that particular term is and acquiesce. So they either just kind of generally ignore that particular requirement to stipulate that, because it's kind of presumed that all contracts for people in that industry would have that particular term in it. And again, it can't contradict an express term in the contract. The next thing I want to look at are collateral contracts. So thinking back to this idea that a representation can be made that's not part of the contract, that's not included as an express term, but can still have some form of legal effect. Well, sometimes where a party has made a representation that is excluded, now often this is excluded because of the parole evidence rule, because the statement was made by party A to party B, but it wasn't included later into the formal contract itself. Nonetheless, they can have some legal effect, and if party A has made a particular representation that isn't incorporated into the contract, but nonetheless induced party B into entering into that main contract, this representation forms the basis of a collateral contract. With the idea being that whatever party A had promised to party B, that's the consideration that they're offering. And the consideration that party B is offering in this little collateral contract is to enter into the main contract. Now the courts prefer this as a strategy. And the reason for that is that the courts don't want to be the destroyer of bargains. It's a much more elegant solution to just look at this representation that was made to induce another party into the contract as a separate contract and just analyze the main contract and the collateral contract independently. So essentially we end up with two contracts. The main one, in which the obligations of the parties are stated as express terms in that particular agreement, and then we have the collateral contract where each of the parties can still sue each other for non-compliance in that. Now, often party B, going back to my example, has already entered into the main contract. And so often their consideration is already executed. It's usually party A that becomes unstuck in this situation where they've promised to do something
and then tried to back out of that promise. It's important to note here that, similarly to implied terms actually, that where there is a particular promise that's made, it still has to be consistent with the terms of the main contract itself. So what do we mean by being consistent? Well, fundamentally, it can't undermine the main contract itself. An example here in Hoyts and Spencer, where Hoyts, the cinema guys, leased some properties from Spencer. And again, there was a structured lease, the main contract. And in order to enter into that lease, it was argued there that by Hoyts that they were promised orally by Spencer that Spencer wouldn't terminate that lease. What's the difficulty here? Well, that promise from Spencer in that case undermines the main contract itself. It just fundamentally doesn't sit with the fact that the main contract gives the right to terminate, and yet the collateral contract that they're offering is to not ever exercise that right. It completely undermines the substance of the main contract itself, and as such is not a collateral promise. Now, the final area I want to talk about is the interpretation of contract. So when contracts are done and dusted, they're enshrined in a document, but when each side comes to perform, there is some sort of dispute about the underlying meaning of what particular words do. In that situation, it's not uncommon for things to end up in the court. And in that situation, the judge is the one who has to interpret what the underlying meaning of particular terms in that contract are. And really the key aspects of contract interpretation are kind of similar to interpreting statutes, in that it's all about the underlying intent. Although here, rather than the intent of Parliament, they're really trying to examine what the intent of the parties were. Now, to throw another spanner in the works, it's not what their actual, or what we call their subjective beliefs about what the words mean. It is what a reasonable person in the situation of each of the parties would think that the words mean. Now, this can be a little tricky to get your head around, but if we sort of step back for a second and think why this rule needs to be like this, it's because whenever two parties would read the same document, if they're in dispute, then clearly they're going to prefer their own interpretation of what a particular clause or term or word means to what the other side thinks is going to be. You're never going to have that meeting of minds. And so the courts have to have this reasonable person test, this objective standard that they use in order to interpret the meaning of contractual terms and clauses. It's also probably important to note here, just as a matter of process, that other than for determining generally agreed upon background facts, the statements that are made by parties during this process of negotiation and memos and such like are usually excluded by the rules of evidence from being adduced in order for the court to determine what the objective intention of the parties was at the time. Similarly, the conduct of the parties afterwards is excluded in terms of trying to determine the results of this particular rule. And the reason for that is that parties clearly, if they believe the contract to be in a certain way, it's their own subjective understanding of what the terms were, not an objective one. From the outset, I have to say there is a lot of literature on this. There's been a fair amount of case law where judges have talked at and looked at this, this true rule of excluding or the pre-contractual negotiation stuff. But still, essentially, this is the law as it stands. And this test, modified by a host of other smaller tests that are outside the scope of this work, is still fundamentally the law and the rules of contract interpretation at its current state. There is, however, one particular rule I just want to draw your attention to. It's something of a pragmatic rule and it acts as something of a tiebreaker in some situations, but in situations where the court can't determine either way, it often does carry and have some weight. It is still a functional rule of contractual interpretation. And there are also some difficulties that the party that is proffering, that is, they are the ones who are coming up with or issuing the particular statement of terms to be accepted by the other side, may not actually be the ones physically drafting the underlying contract, particularly in situations where there's standard forms that they then get modified between the two. And so again, it's a rule, but it is used quite sparingly, and again, as a last chance, as a tiebreaker in situations where the residual ambiguity can't be resolved by the court.